Right, okay, I think we'll start because we've sort of had a bit of a lull in people joining, so I think now's probably a good time to just go ahead, and obviously we'll let people in as they continue to arrive. So good afternoon, everyone. Thank you for joining us for our first webinar of 2026. We're delighted to see so many of you join us this afternoon for what we think is probably genuinely one of the most important risk areas for organisations. I'm Hannah King. I'm one of the legal directors in the employment team here at Harrington Carmichael, and I'll be presenting today's webinar with my colleague Cassie Blackledge, who's a solicitor in the employment team as well. And we're looking forward to just walking you through today's webinar, and obviously we will give you the opportunity to ask any questions at the end as well. So if you do have any questions, please feel free to pop them into the Q&A box, and we will pick those up at the end of the session. So just in terms of what we're looking to cover today, we're going to give you an overview of what we mean by manager liability, before going on to consider what the most common claims that arise and are driven by managers' actions are. And then we'll have a look at the types of behaviours that HR would typically like to see line managers adopt to help reduce and mitigate the risk of those areas. So the heart of the session is going to be a focus on the line manager behaviours we regularly see resulting in claims, before we then go ahead and have a look at how we can try and help reduce that risk. So just going on firstly to look at sorry, I'm just going to hand you over to Cassie, who's going to just talk you through why this topic is important, and then we'll go on to look at the specifics in a bit more detail.
Thanks, Hannah. So if there's one thing HR were to put at the top of its wish list, it's for line managers to understand just how critical their role is in terms of reducing the risk of tribunal claims. The vast majority of tribunal claims don't necessarily start with the HR team. They often start with the day-to-day interactions between employees and their line managers. And as you all know, line managers are typically the first point of contact for almost everything, whether it's performance concerns, sickness absence, family-related leave, grievances, complaints. What we see time and time again is that claims don't arise because a line manager intended to do the wrong thing. They arise because conversations are handled poorly, policies weren't followed consistently, or issues weren't escalated early enough. So from an employee's perspective, the line manager is the organisation. So what a line manager says, does or doesn't do can quickly escalate and become evidence in a claim. So the answer isn't always more policies. It's essentially about better equipped managers, because we all know that prevention is cheaper than cure. Often claims can be avoided with an early conversation, the right processes, or even a quick call to HR. So if there's one thing to take away from this slide, it's that investing in line managers is key. It's not a nice to have, and it's one of the most effective risk management tools that a business has to mitigate the risk of a tribunal claim. Just on then to why line managers matter. So line managers, as you know, have a direct and daily impact on employee experience. They're the ones that manage performance, conduct, absences in real time through conversations. They decide how feedback's delivered, whether issues are addressed early or allowed to drift, how fairly and consistent policies are applied, and whether employees feel supported or not. So line managers essentially set the tone for workplace culture. One poorly handled situation, whether that's a clumsy comment, an off-the-cuff decision, or a failure to follow process, can escalate quickly. So sometimes what starts as a performance issue, whether that's sickness absence concern or an informal complaint, can turn into a formal grievance pretty quickly, as well as a breakdown in trust and confidence, ultimately leading to a tribunal claim. So really the takeaway is it's all about how matters are handled at the outset, and that is why supporting line managers is definitely so critical, because when managers are confident, they're trained, supported, issues are resolved earlier, conversations are definitely better documented, and employees feel listened to, which therefore reduces the risk of a claim significantly. So the way we like to picture it is that line managers are essentially the business's first line of defence. If there are cracks in that line of defence, then the higher the risk becomes towards a tribunal claim. So yeah, I'm just going to pass over to Hannah now to talk about manager liability.
Thanks, Cassie. So as Cassie mentioned, managers can be the first line of defence, but they can also be potentially the biggest liability for a business as well. So when we talk about line manager liability in this context, we're not specifically considering line managers being sued personally for employment claims. However, we're all aware that that is an additional risk and possibility that perhaps line managers don't necessarily always appreciate, particularly in the context of discrimination or whistleblowing claims, that they can actually be named personally in proceedings as a respondent themselves. What we are considering in the context of today's webinar is employers being vicariously liable for the acts and actions decisions of their managers, and that a manager's poor judgment or actions therefore become an organisation's legal risk. And often this can arise where, as Cassie's mentioned, the manager simply hasn't been trained adequately to identify potential risk areas and issues, to understand the best course of action to take. And we will have a look at that in a bit more detail in the next slides coming up. But it is important perhaps for HR to drive home the message that not only is it the business that can face consequences of these poor decisions or actions, it is the managers personally as well. And I have handled a tribunal claim that went to hearing just this year, where we acted for the line manager specifically, who was named personally in a claim, and the business were not prepared to support him in the defence of that claim, so it was something that he had to pick up himself. So it doesn't always go, and it's not always a given that the business will support their managers in defending tribunal claims. There are some circumstances where a business will take the decision to cut that individual adrift and allow them to defend the claim themselves. So if we just look at where we see one of the most common patterns emerging in terms of tribunal claims, it's what we often call the judgment gap. So many managers are promoted because they're excellent technically, they know the job, they deliver results, and they're dependable. But what they're not always given is the training to manage people in a legally safe way. So quite often we end up with managers who have limited understanding of legal risk, that they feel pressured to act quickly, that they rely on what they perceive to be common sense rather than processes. They avoid having difficult conversations because they don't know how to handle them or don't want to upset people. They keep poor or no records of discussions, and then they can sometimes communicate inconsistently or informally. Cassie mentioned this before, but crucially, this is not about bad intent on their part. In the vast majority of claims that we defend, there is no deliberate wrongdoing or intention on the part of the managers to do anything unlawful. The manager is trying to be, in most circumstances, pragmatic, human or efficient. But that's where they can become unstuck. And employment law doesn't judge the intent necessarily, it looks at the impact and the processes. So a well-meaning off-the-cuff comment can become evidence of discrimination. A helpful shortcut could become procedural unfairness, and a delay because someone's avoiding conflict could potentially become constructive dismissal, for example. So HR are often in the position of seeing where these situations go and the risks before anybody else does. And the challenge is bridging that judgment gap between the managers and giving them the confidence, language and structure to handle people issues in a way that feels natural and stands up legally. In the next slide, we're going to have a look at certain situations where that gap often comes up, and I'll hand you back to Cassie, who's just going to give you an overview of the claims that we typically see in this context.
Thank you, Hannah. So as we've, I guess, spoken about already, most of the serious tribunal claims are driven by how managers react in the moment. So I'm going to talk through each of these claims. So with whistleblowing, employees rarely make a claim in the tribunal because they've simply just raised concerns. The claims arise afterwards when the employee feels that they've been treated differently, whether that's that they've been excluded, they've been criticised or sidelined, or even labelled as difficult. Line managers might not necessarily see that as retaliation, but legally it can be considered a detriment because an employee's raised concerns, they've been treated less favourably, and then suffered a detriment as a result of that. Then moving on to constructive unfair dismissal and unfair dismissal claims. So here we're talking about employees with at least 2 years service. So as we all know, currently employers have the protection of an employee needing 2 years service to bring these claims. Of course, we mustn't forget the automatic unfair dismissal claim that an employee can bring as a result of whistleblowing or discrimination, and they can have less than 2 years service with those claims. The risk, obviously, of a constructive unfair dismissal and unfair dismissal claim is likely to rise in 2027 as a result of the Employment Rights Act 2025, because the qualifying service period is reducing from 2 years to 6 months. So what we're talking about today is going to become even more important at the end of this year onwards. Just taking, I guess, constructive unfair dismissal by itself. So these claims arise as a result of a series of management actions. And as we all know, the most common breach relied on is the breakdown of trust, the breakdown of the implied term of trust and confidence. And that's caused generally by poor communication, failure to address issues, and inconsistent treatment. And the resignation is simply the final step. Then just moving on to unfair dismissal, these claims typically stem from rushed decisions, inadequate investigations, failure to follow process, and managers sometimes deciding the outcome before a process is concluded. Then we've got victimisation. So once an employee has raised a grievance, for example, particularly where the complaint relates to discrimination, managers have to tread carefully. So any negative treatment afterwards, where discrimination's involved, even if it's unintended, as we've spoken about already, can quickly be framed as victimisation. And then just lastly on this slide, so we've got discrimination and harassment. And these claims typically arise as a result of inappropriate comments, such as banter, unconscious bias in decision-making, or managers failing to challenge behaviour within their teams. So especially with harassment here, from a legal perspective, it's not about the intent, as we've already spoken about and Hannah's just mentioned, it's always about the impact. We're now going to look at these high risk behaviours in detail separately. So we're going to go through what poor communication looks like, failure to follow process, mishandling performance management, mishandling grievances, unconscious bias, and then retaliation after concerns are raised. So just handing over now to Hannah to talk about avoiding the B word.
Thanks, Cassie. We're going to start off what we consider to be perhaps the key aspects or wish list that HR would want their line managers to know. And the first one on the list is avoiding the B word, banter. If I had £1 for every time we heard it was just banter, I would be a very rich and happy lady. However, banter is actually probably one of the most dangerous words that's used in workplace disputes. It's usually deployed after the fact when something's landed badly or somebody is upset. Banter is not a defence to a claim. And if a comment relates to a protected characteristic, which frequently it does, such as sex, race, age, disability, sexual orientation, and it has the effect of violating someone's dignity or creating that hostile, intimidating, offensive environment, it can obviously fall squarely within the scope of a harassment claim. It doesn't matter that it was meant as a joke, that others laughed, that the team all talk like that, or that the person making the comment didn't mean any harm. What the tribunals will look at is the effect on the recipient and whether it was reasonable for them to have felt that way. The other thing to bear in mind that frequently isn't always appreciated by line managers is that the definition of workplace in the context of discrimination claims is much broader. It doesn't have to have happened on the premises in working hours. Quite often these things can arise in the context of a comment that's made outside the workplace, at the pub, at a social gathering, at a work event or Christmas party. And so it's really important to keep that in mind when sort of ensuring you get the message home to managers that what banter means and when it can arise is much broader than strictly what's said in the four walls of the workplace. And actually just referring back to that here, and that I mentioned that I've had this year with the line manager, the comments that he made, his immediate reaction when these were put to him was it was locker room banter. And actually it was made at a social setting with his team outside of work when he was trying to essentially build relations with his new team. So it's often fueled perhaps by alcohol, and that's sometimes a consideration as well, but it doesn't matter typically that these things can arise more frequently outside the confines of, strictly speaking, the normal workplace. And that's really where your role as HR professionals is crucial. It's important that organisations, if they want to be able to defend these claims successfully, can broadly show 5 key things. Firstly, that they've drawn attention to policies and procedures, particularly around diversity and equality, discrimination, harassment and bullying. That your leaders are setting a good example and that live the standards that are expected by the organisation. That the culture of the business doesn't tolerate discriminatory language, that people are informed and warned and aware that certain behaviours can lead to disciplinary action being taken against them, and that there is that open dialogue and forum and ability for people to raise concerns early, and even if they don't relate to them personally, if they've overheard something being said about somebody else, that they feel empowered to bring those issues forward. It isn't about creating humorless workplaces. It's about recognising that what feels harmless banter to one person can be exclusionary or humiliating to another, and that's where the legal risk sits with the employer. So the sort of message we always try to get home is that if you wouldn't be comfortable seeing it read out in the tribunal, don't say it at work. And the message for HR really is don't allow banter to become cultural shorthand for behaviour you would never be able to defend in front of a judge. And that's sort of one of the key considerations, because quite often things said in jest in the moment, when they're actually then read back to somebody in witness evidence in a tribunal forum, it does create a pretty uncomfortable situation for them. And that is indicative of the fact that those types of things aren't appropriate in the workplace. The next wish list item is communication. Oh, sorry, I've managed to skip forward there, because this is where so many cases can be won or lost. The risk factors in this particular area are fairly familiar. So we've talked about this a little bit already, but usually it comprises of off-the-cuff or unplanned conversations, overly harsh or emotional responses, and inconsistent messaging between managers. And these are exactly the situations that can generate legal exposure, such as constructive dismissal, unfair dismissal, or discrimination claims. This can sometimes look like a manager calling somebody into a room to have a word, and then another manager says something different the next day. No notes are taken, emotions can run high, and then 6 months later you as HR professionals are then put in the position where you're trying to reconstruct what was said by whom, what tone was used, and the only evidence you have available to you is the employee's statement and their version of what happened at that time. Compare that type of situation with what could be considered good practice, which is where conversations are planned, the message that the manager is trying to convey is clear, factual and consistent, that any expectations or consequences being discussed with the employee are clearly explained, and that notes are taken and retained. So if they do need to be looked back on and considered a number of months down the line, that there is that contemporaneous record of what was said. From a legal perspective, that type of mitigation of risk protects the organisation, it protects the manager, and importantly, it protects the employee as well by giving them clarity as to what the expectations are and fairness in terms of any process. So the purpose here is not for HR to intervene and for their role to slow the business down. It's to give the managers the framework to have difficult conversations so they are held timely, lawfully, and then in a defensible way. because quite often in employment claims, it doesn't matter necessarily just what you decided. It matters as well how you got to that decision and how you communicated that decision as well. And those types of steps and mitigations can help make that mitigation minimise the legal risk in those situations. I'm going to hand you back to Cassie now, who's going to look at the next wish list item.
So the third item on our wish list, so it's an area we see that generates legal risk more quickly than others, and that's sickness absence not being followed correctly in terms of the process. It's a classic example where inconsistency, frustration, and assumptions can turn an operational issue into a legal one. And one of the biggest risks in this space is the inconsistent application of sickness absence policies. So on that note, managers should ensure that employees comply with sickness absence policies, provide the appropriate fit notes, attend review meetings if required, but also managers should look at carrying out welfare checks because they're very helpful. If absence procedures are followed correctly for one employee but flexibly for another, that again creates risk and inconsistency and can easily be relied on as evidence of unfairness or discrimination. We also see comments made in the moment. They can be particularly damaging, specifically where someone expresses disbelief or suggests an employee is always off, or generally just shows frustration about the impact of someone's absence on the wider team. And that is quite typical. Even if the harm is unintended, those comments can become evidence in a tribunal claim and can be particularly damaging. Another common issue we see a lot is businesses and managers ignoring medical evidence. So someone provides a fit note or even occupational health advice. Any underlying conditions, whether mental or physical, should be taken seriously and not just selectively relied upon when they support a particular outcome. Equally important is not letting sickness absence drift. And problems generally arise when managers avoid conversations, perhaps because they feel uncomfortable. So definitely early intervention and an early referral to HR is critical. It's not good enough when the situation has already been escalated. Here it's not about being punitive, it's about being proactive and supportive. And I think also an important thing to note is managers also need to be alert when absence might be disability related. And that doesn't mean that the employee is going to provide you with a diagnosis or medical certainty. It's simply about recognizing pattern, context, and duration, and know when to pause and actually ask yourself, like, could this result in a disability discrimination claim? Does the employee have that long-term condition that's lasted 12 months or likely to last 12 months that a line manager or someone else in the business even is aware of or could reasonably be aware of and impact their day-to-day activities? So long-term sickness is slightly different in that it requires a different focus, and the approach should really be support and communication. Or even exploring reasonable adjustments, so altered duties, phased returns, different hours, temporary adjustments to workload. I guess the takeaway from this slide here is that managers should avoid assumptions, processes should be followed, and involve HR early if you need to. And you can't really go wrong if you do all those things.
Mm-hmm. And just on that, quite often we see, don't we, Cassie, particularly in relation to constructive knowledge of disability, that in tribunal claims, the employee will say, whilst HR may not have necessarily been made aware of a condition, they will say, well, I did this, it came up frequently in conversations with my manager, so you should have been aware of this. And that there's sort of a disconnect between the manager then communicating that down to HR, and that can sometimes then put HR and the organisation in a difficult position where they can't have taken action that they didn't know needed to be addressed. So
yeah. Now just looking at following correct performance management processes. So performance management is one of the most common routes to an unfair dismissal or discrimination claim. And they're often brought not because there are issues that exist, but because the processes, again, aren't followed properly. The most common performance process we see is obviously the performance improvement plan that we all call a PIP. And in principle, they work well, but in practice, they can become very high risk when not managed correctly. And just looking at one of the biggest pitfalls, that's definitely moving the goalposts. So essentially targets are set, the employee works towards them, and then suddenly the expectations change, or new issues are introduced that were never previously raised. Another common issue we see is unrealistic or unachievable targets. So objectives should be reasonable and measurable and within the employee's control. We frequently also see, and this one comes up a lot actually, is little or no documentation. So without a clear paper trail setting out concerns or support that's been offered, meeting notes, progress reviews, employers are left exposed. Time is definitely another critical factor, so employees must be given a reasonable opportunity to improve. A PIP that lasts a few weeks, particularly for complex roles, is not sufficient. They should last for about 3, if not 6 months, sometimes even longer. So if I were to say what good practice look like when it comes to PIPs, definitely proper investigation into the issues at the outset. So understanding what those performance issues are, separating capability from conduct, and considering the underlying factors. And then also concern must be given to clearly communicating it with the employee. So they should know what the issues are, why they matter, and what improvement looks like for them, so they can have a target to reach. On a similar note, objectives should be clear, reasonable, genuine, and they should be provided with regular feedback. And then again, as I just mentioned earlier, timescales should be adequate and realistic. Again, just going back to the disability point, we've got to be able to adjust. So where there's a disability or an employee has a potential disability, we may want to consider adapting targets, extending timeframes, or providing additional support. Back to you, Hannah.
Thanks, Cassie. So looking at next wish list item is timing. So Cassie touched upon this briefly in relation to sickness, but really timing is one of the critical considerations and potentially one of the biggest risks we see in practice. It's not, sometimes the question is not necessarily what employers or line managers have done and whether those actions were justified, but the timing around when they have decided to do something. So letting issues drift doesn't necessarily make them safer. In fact, it can make them potentially more risky. From a tribunal perspective, delays often can immediately raise red flags with claims. Judges can ask, well, if this was so serious, why wasn't it dealt with at the time? And if it wasn't so serious then, why has it now suddenly become such a serious issue now? There are generally 3 recurring risk areas that we see. Firstly, long delays before action, particularly around performance or conduct. If issues are tolerated, explained away, or handled informally for months or even years, then it become difficult that when formal action is finally taken, an employee can argue that they've been ambushed, there's been inconsistency of treatment or lack of a fair warning, and sometimes that argument can land with a tribunal for their consideration. Secondly, suddenly remembering issues at certain trigger points. So if you've got a redundancy selection process that becomes relevant, and you suddenly are thinking about scoring employees and you're looking at how they've performed and you haven't tackled or raised those performance issues with them before, and you score them accordingly, and then there's a sort of disconnect between their understanding of how they feel they're doing and perhaps the line manager's understanding for the basis of that assessment. It can also crop up in the context of sickness absences, whistleblowing, or even pregnancy matters as well. Even where their underlying concerns are genuine, if the timing of when these things are raised, it can look opportunistic, and that's where claims can escalate. So if you haven't raised an issue and then somebody does make what they consider to be a protected disclosure, and then you need to look at tackling certain performance or conduct issues with them, the timing can look suspicious in terms of how and when that lands, and whether it is actually for a genuine reason relating to their conduct or performance, or if it's because they've now made what they consider to be this protected disclosure. Similarly, with employees that become pregnant, if there are issues that haven't been addressed with them before, if you then try to look at tackling those post-pregnancy, it can look suspicious in terms of the timing and whether actually these are genuine concerns, or if they're now being treated less favourably because of their pregnancy. And that's where things can escalate quickly into the territory of discrimination, potential detriments on whistleblowing grounds, or automatic unfair dismissal territory relating to pregnancy and maternity, or whistleblowing as well. The third risk area we commonly see is only acting once the relationship breaks down. So managers often cope informally whilst relationships are good, but once trust erodes, everything can suddenly become a lot more formal, and tribunals are very alive to that narrative as well. And I think Cassie obviously mentioned, in the context of constructive dismissal claims, a breach of the implied term of trust and confidence is almost always relied upon and referred to in a claim for constructive unfair dismissal. It's by far the most common breach of contract that's relied upon in the context of a constructive dismissal claim. So in terms of line managers' approaches to this, what we commonly hear is that managers are reluctant to tackle these issues because they hope it's going to blow over or resolve itself. They're avoiding confrontation. They look to handle things informally when it's not appropriate to do so, or they're concerned about upsetting the employee. And all of those instincts are human, but they can also potentially be legally dangerous. What we would advise instead is having clear escalation routes, so managers know when informal management ends and formal processes need to step in. Providing early support and intervention to their employees, not to punish, as Cassie said, but to evidence reasonableness in the approach the line managers have adopted in tackling those issues. Have difficult conversations early when resolution and de-escalation is still realistic, and you can look to adopt alternative processes, such as potentially things like mediation if it is a relationship issue, that can be deployed early on to resolve those issues at an early stage. And critically, keeping some form of written records, even at an informal stage. That's really helpful, even if it's just a sort of a note to self, a summary of what was discussed, because it's really difficult to look back at these conversations years down the line and recall exactly who said what, and to challenge what the employee is now saying was said to them and how it was presented. So early action in this context is not being about heavy-handed, but it's about preserving options and credibility, where a delay would potentially remove those. The next wish list item we're going to consider is consistency. This is one of the most useful and underestimated options and concepts in employment context. Inconsistency can fuel unfairness arguments, and we see this phrase or variations of it used in tribunal judgments a lot of the time. The most common employee refrain is the one referenced on the slide there, is that, but you didn't do this last time. So there's sort of confusion and the lack of understanding as to why an approach has changed from what was previously adopted. That doesn't mean that the previous decision was or wasn't right, but you now have an issue with regards to a potential precedent problem. Managers often think that consistency means coming to or arriving at identical outcomes. It doesn't. What it means is consistency of approach, reasoning, and process. So if two employees are treated differently, and frequently that will be right and necessary, line managers and HR will need to be able to explain to a tribunal why the situations were materially different, and why the business has approached why the business approach has legitimately changed. So if you can't explain clearly and contemporaneously why that is the case, a tribunal will frequently assume the worst. And in the discrimination context, all the employee has to show in order to push the burden of proof from them to the employer is that there's enough evidence to raise an inference that there's been discrimination, and then the burden of proof shifts over to the employer to demonstrate why they weren't treated that way because of something related to a protected characteristic. This is why managers really need to understand a precedent risk. One informal decision made to be kind or to keep the peace can then set expectations across the workforce. And inconsistency can then feed into claims for, as I mentioned, discrimination, breaches of trust and confidence, and unfair dismissal claims. HR often understands the need and requirement for consistency instinctively, but the challenge really is equipping managers to recognise when a decision today potentially could create some kind of legal exposure later down the line. And that's why things like framework, documentation and HR oversight on certain matters are really important, not to remove that manager's discretion to make decisions, but to make that discretion then potentially defensible if needs be. I will pass you back to Cassie now, who's going to talk you through the next item. Oh, sorry. There we go.
Thanks, Hannah. So one of the biggest drivers of legal exposure is HR being brought in after the damage has already been done. Problems don't escalate because managers don't care, because often they really do. They have that relationship with the employee. They escalate because decisions, again, were made too early, policies weren't followed, and sometimes where issues are dealt with informally for actually far too long and without any input from HR. Some examples to give here: a quick chat between a line manager and an employee turns into a commitment, an informal warnings delivered without any process. And sometimes we do see it quite often, don't we, Hannah, where a decision's made in the moment just to keep things moving, but it's done too early. By the time HR gets involved, the company's already committed to a position, and it's very difficult then to unwind from that. So a conversation with HR at the outset can stop that issue. It can slow things down, identify legal risk, and prevent these irreversible mistakes. And that, again, is really important where we're looking at sickness, absence, performance, grievances, whistleblowing, or anything else that could engage discrimination protections. It's really important to involve HR. They can help steer you in the right direction, choose the right processes, using the right language, documented decisions properly, and avoid doing something or saying something that later becomes evidence, detrimental evidence in a tribunal claim. And HR isn't there to block decisions. They're there to help. They're there to protect the business. And it's not about waiting until the employee's resigned or a grievance is raised or legal correspondence has landed. And I think that a lot of the times is where it can potentially go wrong. So definitely keep managers and HR having conversation between themselves, involve HR early, resist the temptation to resolve complex legal issues on your own, and don't take informal shortcuts. So this slide is all about the risk of retaliation. So again, as we've spoken about already, so it's a high risk period. Once the employees raise the concern, the legal risk landscape changes immediately. And at that point, retaliation becomes a central risk. And as we've said earlier, retaliation doesn't have to be obvious. It doesn't have to be deliberate. It often shows up in subtle everyday management decisions. So it can be, for example, excluding an employee from a meeting that they would usually attend, or removing them from a project because maybe they've complained about health and safety without having a reasonable explanation for doing so. The intent is generally irrelevant. What matters is if an employee can generally show that they've been treated less favourably because they have raised that concern, that's the crux of the matter. And what makes these claims particularly risky is that the timeline often speaks for themselves. So if the employee can show that generally they've raised the complaint or concern and then negative treatments followed shortly afterwards, the timeline speaks for itself, and that sequence alone can be enough to shift the burden of proof in a tribunal claim. I think Hannah touched on this earlier, and it's important to sort of speak about managers being mindful of their tone and language. And we've recently had it where an employee submitted a DSAR. That DSAR, well, the data output from that DSAR found that someone was made redundant, but that decision to make them redundant was predetermined. That then's provided to the employee as part of the data output, and then found its way into a tribunal claim. So as Hannah mentioned earlier, our top tip generally is draft emails and say things to each other that will generally be read or heard by a tribunal. The same thing can be said really for comments made out of frustration. Take time to think, or even say, oh, I'll come back to you on this if you don't know how to respond straight away. The safest option is generally to pause, speak to HR and manage the employee. You don't always have to provide the answer straight away. You don't have to respond at the drop of a hat. And I guess also it's worth mentioning, if generally like changes to duties, performance management or team interaction, like changes to that are generally necessary, they must be justified. Write down why you're not allowing someone to attend a meeting or why you've taken someone off a project. It might be because they've got more skills to work on another site of another project, and that generally suffices. Just make sure it's carefully documented and you've obtained HR advice in that respect. So I think it's the key message from this slide is that don't punish an employee for speaking up, whether that's overtly or subtly. I'm just going to pass back to Hannah to talk about manager training now.
Thanks, Cassie. So all of this brings us to training, ultimately, at the end of the day, not generic tick box training, but targeted manager training. That is by far your most effective tool as HR professionals to try and get your managers on board and to mitigate the risk that they do something that can then create and result in legal claims. So well-designed training does three critical things. Firstly, it reduces costly claims. From our perspective as solicitors, training is one of the few preventative measures that can consistently help and stand up to scrutiny in Employment Tribunal if an employer can show that they did undertake, all reasonable steps in terms of discrimination, but also just general training in terms of how to approach management of staff and employees. Secondly, it improves confidence and decision making for your managers. Managers quite often delay action largely because they're unsure. They're unsure what they can say, unsure how formal something should be, and unsure when HR needs to be involved. So by training them effectively on that, it will give them that confidence and ability to make appropriate decisions. And thirdly, it helps feed into that wish list item of consistency across the business, which directly addresses some of the risks that we've already discussed. On the slide, we've listed some areas where we consider would be appropriate to focus training, because it's in those sort of areas where line manager input is fairly critical, and or often where claims can arise. So obviously disciplinary and grievance basics. Quite often the line manager is the first port of call when handling a disciplinary process, and therefore they need to be equipped with the ability and understanding as to what that process entails. Again, grievances, if the grievance isn't against them directly as the line manager, quite often they will be the first person that would be asked to investigate a grievance relating to one of their the team members. Harassment, again, this comes back to sort of that day-to-day interaction and banter type area. Reasonable adjustments, so identifying perhaps where you have somebody in your team who does seem to be having a prolonged period of absences or repeated short-term absences, and whether there's an underlying issue that needs to be investigated, and being able to identify perhaps where some interventions required. Performance management, Cassie's discussed quite extensively already, but the ability to be able to implement proper and effective performance improvement plans is not only good from a risk perspective, but it's good from the business's perspective, because investing the time in an appropriate process, the intention of a PIP always is to try and bring that employee back up to standard. And if you can do that effectively by an appropriate performance improvement plan, then you're bringing that employee back on board. They feel empowered, their productivity and performance is improving, and everybody benefits from that. Sickness absences, again, that sort of feeds into the reasonable adjustments, but being able to identify perhaps where there's an issue of of a disability and something that might need a bit more scrutiny and exploration is really important as well. Whistleblowing, so equipping your managers to identify potentially when an employee may have raised an issue or concern that could potentially fall into or stray into the territory of a protected disclosure is important as well, because what we want to avoid is any suggestion of a causative link between any concerns being raised and then any subsequent action taken by that line manager, which the employee can frame or perceive to be detrimental. And then how to document effectively throughout. So whilst we've talked a lot about keeping notes and documenting things, and that is really important from decision making and evidential perspective, it's also really important to be mindful of what you commit to writing as well, because as Cassie said, ultimately things will be put before an employment tribunal in terms of evidence, and so sometimes you don't want to commit everything to writing. So particularly where you're seeking HR guidance or support on certain elements, where perhaps the outcome is that you're looking to perhaps see if there's a way to exit that employee. In terms of sort of some practical improvements or things that HR can deploy to try and help with manager processes and sort of meetings, etc. We would strongly suggest things like checklists and templates if you have them available. They help reduce variation and panic decision making. Think about whether your business has the ability to implement some kind of mandatory HR sign-off for high-risk decisions, particularly around dismissals, pregnancy, long-term sickness and things like that, to ensure there is that appropriate HR oversight at an appropriate stage. Producing some kind of outline or script for holding tricky conversations on common subjects, not to make managers robotic, but to keep the language safe. And then whether you can implement things such as flow charts for performance and absence management processes, so they can see what's involved in that process, understand and know what's going to come next. Then one of the key things for HR to do as well is to perhaps keep track of manager issues, so you can identify risk areas and perhaps where there is a need for further training and focus for your line managers going forward. From our perspective, these measures do two things. They improve the outcomes of the engagement and interactions with line managers and their direct reports, and then they create hopefully an appropriate level of evidence to support and defend a claim if need to be going forward. So that's the end of our session this morning. We're going to open the floor up to any questions that anybody might have. And also just to flag, we've got our next webinar taking place in February, being hosted by our colleagues Tom and Alice, and that's going to be on ChatGPT and why workplace disputes are getting more complex. So there's a QR code there for you to sign up to that one as well. But just have a look at the Q&A section. Okay, so we've got a couple of questions. So if HR are aware of a medical condition, do they need to share it with the manager? We would generally suggest and encourage the colleagues to share information with their manager from a wellbeing point of view, but we don't necessarily insist on it. I think that's right. If it's a sensitive issue, then provided HR are aware, then the business is potentially aware of that condition, such that the protections under the Equality Act in terms of potential disability would be triggered. And sometimes line managers can be frustrated by the fact that perhaps they don't feel they're getting all the information that they consider that they should be entitled to. But if somebody has come to HR in confidence in relation to a medical condition and HR are managing it accordingly, then they shouldn't necessarily be in a position where they should be sharing that with the line manager, unless it's absolutely necessary and that they have the agreement from the employee to do so. The other question, I assume if you have a confidential whistleblowing hotline and an employer does not know who's raised a whistleblowing claim, which has then been investigated, then an employee cannot claim that they've been treated less favourably if an employer does not know that that something's been raised. Yeah. So if there's no indicators and it's not possible to identify who has raised that complaint, then it will be really difficult for an employee to show that there is that causative link between those protected disclosures that they may have made on the whistleblowing hotline and any subsequent treatment that they've been subjected to, which they consider to be detrimental. Because that's the claims for whistleblowing have two key parts. Firstly, the employee has to establish that they've made that protected disclosure in the first place. And then secondly, that if they have, that they have been subjected to that treatment because of the complaint or disclosures that they have made. Will there be a recording? Yes, there'll be a recording available for the webinar. Absolutely. We will share that with everybody after on email. Are there any other questions from anyone else? No? Brilliant. Well, thank you so much for attending today. As I said, we've got our next webinar in February, so do feel free to sign up to that one as well, which I think is going to be another interesting topic. It's definitely something that we're seeing, becoming much more an issue. But I hope you found today's session useful. And yes, absolutely, we'll share everything in terms of the slides and the recording after the session. If you've got any other questions that you think of, do feel free to reach out to me or Cassie after the session as well. So thanks very much.
Thanks, guys.